sir.
Good morning. This is the time set for case D21635-772D. We have the parties and counsel present in court. We'll start with the plaintiff. You want to go ahead and state your name and go ahead with your elected attorney. Go ahead and state your bar number 2, please.
Dylan Houston, Procedural number 13697.
All right, thank you. And
Good morning, Your Honor. Dana Dwiggins, bar number 7049. Here on behalf of both Julie and Paul Page, who are present, my associate Ross Evans, and my paralegal Austria Dwiggins.
have any issues been resolved?
No.
Okay. And I'm going to come back to that in a minute. Exhibits. Have there been any agreements regarding exhibits?
No, I attempted, Your Honor.
All right, as we discussed at the counter call, we give you up to 8 hours each, and I'll keep track of time for each side. Obviously, the interveners have the burden of proof, so they will go first. And that time will include the opening, closing, cross-examination, any longer speaking objections. I reserve the right to put those on the party making them. I'm also going to vacate the hearing on January 27th. I'm playing this motion for reconsideration. I have reviewed that, and that was an interim order. The court will hear the evidence and make any findings necessary based on what that evidence is, including the backtrack reports and orders. This case is pretty extensive, and the filing of it, we're up to 377 documents filed in this case. So, and I inherited it, so I had not read all the orders and haven't committed all the orders to memory on that. What I would like to do, unless somebody objects, is take a few minutes with Mr. Houston and counsel off the record and discuss, as I know you guys have engaged in some settlement negotiations. I want to try to see where they fell apart and see if there is a chance before we go through 3 days of this. And see if there is a mutual ground we can come to.
Is that something that would be in chambers, Your Honor?
Yeah, on the conference room, yes. Mr. Houston, do you have an objection to taking a few minutes to do that?
Well, I'd also like to be heard on a motion to strike the petition before we start the trial.
Okay. All right. So you want to do that first?
I haven't seen the motion to strike.
It's going to be an oral motion.
We object to that, Your Honor. He's had plenty of time to file anything prior to the start of trial.
Well, Your Honor, it deals with the failure to disclose documents until the eve of trial, so no, I could not have done that.
Okay. Well, on the documents, if there's something disclosed, and I saw that you filed an objection to authenticity, and I'll deal with those things as things attempted to be admitted. But the answer is the petition definitely has a factual basis in both end the custody and the alternative for visitation for the maternal grandparents. So I'm not going to strike them or dismiss their petition for that. There is enough basis for them to go forward. They made a prima facie case, and that was determined by the prior judge as well, so that I have to go forward with the trial. But I understand what you're saying regarding the exhibits, and I'll deal with those as we come along.
Well, yeah, they didn't disclose any witnesses or documents until December 10th.
Any of the what documents?
The interveners did not disclose a single witness or document until December 10th, which amounts to trial by ambush, but because there was no ability to prepare for trial.
Your Honor, that's not true. There was like 3 or 4 supplements filed by Mr. Jones. And all witnesses were listed and documents disclosed. There were some additional documents that I admit were disclosed on December 10th, but they're not even marked as exhibits.
The documents disclosed by Mr. Jones are not their documents. They are a separate party. They're interveners represented by Ms. Dwiggins. They have to disclose their own witnesses and documents.
Disagree with that, Your Honor.
Okay. Well, part of the, I know that there was a lot of stuff filed all at once in this regarding there's two petitions to intervene and for custody and visitation. So you definitely are on notice, and technically Lexi Page has not withdrawn even hers, and I don't believe she did formally withdraw her petition.
She did.
Did she through counsel? I know he withdrew, but I think it was left open, and I'm going from memory, I have not reviewed that hearing. That was left open, and whether she was actually going to come to trial and represent herself and pursue that, or combine with the maternal grandparents in as far as counsel or represent herself. So she hasn't withdrawn that. You definitely are on notice of all the documents that were produced by her as well as a party to this case.
She didn't produce any documents.
Well, Mr. Jones represented her.
And he represented Ashley Houston, and those were all disclosed.
So, I mean, it's not a gotcha on disclosure in terms of this case was set before the April 8th event for a trial on defendant's request to change custody. And you guys have been litigating that for 2 years. So the stuff that was disclosed and that is fair game for anyone to use. You've had counsel throughout this until very recently. And so if your counsel was disclosed stuff as part of the litigation between, let's say, mom and dad, that is fair game. So I'm not going to, like I said, I'm not going to dismiss or strike the petition for custody or the alternative visitation. If we don't come to a resolution, that has to be tried.
I would just reserve the right to object to the specific witnesses that were first disclosed late in the game, I guess.
Okay, and that may be fair, and I'll deal with that on a needed basis as offered, because I don't know, there may be lots of witnesses that were disclosed that may not be called, so I'll deal with that at that time. And obviously, all of you are entitled to call the witnesses disclosed by each other as well, so I don't know what that is, but what I'd like to do is go off the record, take 10 minutes and see where the dispute really lies in getting a settlement if we can. So, and nobody objects to that, I'll meet you guys in the conference room there and go off the record.
It's today.
I'm gonna have, let's have the party sworn in.
Stand and raise the right hand. You and each of you do solemnly swear the testimony that you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
All right. We've worked on a settlement, come to a global settlement of the current issues before the court. Ms. Dwiggins is going to put on the terms and then we'll canvass everybody.
Your Honor, I did just speak to Dylan in relation to the time split, but the parties will share 50-50 custody for the entire year of 2025, week on, week off, with the Pages week starting on Monday of next week, because they have week. And then for the remainder of the week, this week that is, they will get them at 5 o'clock today, and Dylan will get them on Thursday
Thursday after 5?
At 5. So
Today at 5 o'clock, the Pages will have custody of the children. Dylan will have custody of the children at 5 o'clock on Thursday, and then starting on Monday at 9 a.m., that will start the week on, week off. Absent circumstances that could be addressed at the court with the court at a later date, starting in 2026. The Pages' custodial rights will revert to grandparents' rights, where they have every other week from Friday after school, or if they're not in school, at 5 o'clock until Monday at 9 a.m. Again, that every other week will coincide with when they have, and will continue until the end of the spring semester. And Dylan will pay 100% of the tuition relating thereto. The Pages will forego any reimbursement of the tuition they've paid for the fall semester and the summer of 2024. It is agreed that the children, especially, will continue counseling with Penny Fife as she recommends, and the cost will be split half and half between the Pages and Dylan. Starting in 2026, when the grandparents' rights kick in, the Pages will additionally have 2 weeks during the summer months, so long as the months are non-consecutive. Excuse me, the weeks are non-consecutive, and they will additionally have a week during winter break.
That'll be the non-Christmas week.
Correct. There will be, I don't know what the correct terminology is, interlock?
Yes.
An interlock will be installed in Dylan's vehicle for 6 months. The children will continue with extracurricular activities. Paul will remain the guardian of the estate until such time as a resolution of the wrongful death action has occurred, and then it will be addressed at that point in time with this court. Starting in the school year of 2025, the children will attend academy if they're accepted into the schooling, with all expenses paid by the Pages, including uniforms, any technology or other costs associated with the private school. In the event they do not get into, then they will go to another private school, again, at the expense of the Pages. And any other school Dylan must consent to, however, his consent cannot unreasonably be withheld.
All right, so on the cost, to make sure it's very clear, it's books and technology fees, registration, tuition, and uniforms
Correct.
that they're committing to pay for.
All expenses associated with the private school.
Right, and so if it's going to be a different school,
Other than
they need to tell him by like April 1st, so he can get time for everybody. He can get, if they tell you by April 1st, do you think by April 15th you could give them a yes or no?
Certainly.
Okay, just so we have a plan there. All right, anything else that needs to, any clarifications, Mr. Houston?
Only to the extent of the previous Penny Fife costs. I don't know, I gave them a check. They're fine to keep that if they want, but I didn't hear anything addressing that.
Oh, yeah, I will acknowledge that he did pay him all of the counseling fees incurred so far, but going forward, it would be split equally.
Is that acceptable to you, Mr. Houston?
Yes.
Okay, all right, well, those are all the terms and clarifications. I will start with Mr. Houston. You have heard all of these terms that were just put on the record, correct?
Correct, so I guess one more clarification
Yes.
about the interlock. I have no idea how to get that set up, so it ends 6/30/25,
Yes.
and then I'll work on getting it set up, but I don't know how long that will take.
Okay, and just communicate with council what you've got it on. But yes, June 30th.
Could
2025.
we do 6 months from installation?
Well, I'm hoping you get it installed there. Let's
I
do
mean,
June.
just
I don't know what it
Just like the
entails.
scram, I don't know, it took me like a few days or a week to get it set up. I assume it would be similar time for him.
Yeah, and if I need to, I can.
And there's no restrictions on me driving the kids in the girl.
Right. We want that in there, and you've agreed to do that at your expense until June 30th. Beyond that, you're not, as of today, you're taking off the scram, you're not doing any more scram, any more backtrack.
Okay.
That's understood, Mrs. Wiggins? He's gonna be taking off the scram today and not doing any more backtrack. Okay. All right, Mr. Houston, do you understand all of these terms?
I do.
And are you voluntarily agreeing to these terms to settle disputes between you and Mr. and Mrs. Page?
I am.
And do you believe that these terms are in the best interest of your children?
Yes.
And I know you're on the scram list, so are you under the influence of any medications or drugs or anything that would affect your ability to understand and agree to these today?
No.
And are you being coerced in any way to agree to these terms?
No.
And I'm being careful, even though you are a licensed attorney, be careful because you are representing yourself to make sure that you've had full opportunity to understand and agree to these.
Yes.
And then with this agreement, the parties are also waiving the right to appeal these orders. And Ms. Dwiggins, you're gonna prepare a full order with these and send it to Mr. Houston to review and sign off, or give him time at least to do that. If he doesn't,
Correct, Your
then it
Honor.
can be sent to me.
Correct, Your Honor.
You understand?
Are we gonna address anything about, if any party wants to change this, it needs to be a substantial change in circumstances, anything like that? Would that be a part of the order?
And that is part of, under the Houston, is it Mabel Jones, Hudson, that's the case, Hudson case. It does have to be a change of circumstance, even when there's grandparent visitation, you can't just come back in either side. They can't come back in with no changes in circumstances and say, I just don't like it anymore. There has to be a material change in circumstances affecting the well-being of the children to make a change for either side.
Understood.
That makes sense?
Yes.
Ms. Dwiggins, you want to canvass your clients?
I'm sorry?
Did you want to canvass your clients about the settlement?
I wouldn't mind if you do, so
Okay,
you kind
all
of have it
right.
listed.
I just want to make sure we get, also, they're also kind of far from the microphone, so make sure you speak up to the microphone, you up. I'll start with you, Mrs. Page. Do you understand these terms?
No, you.
Yes, sir.
Oh,
Yes, I do.
And are you voluntarily agreeing to these terms?
Yes, I am.
And have any questions about these terms been answered by your counsel?
Can you say that one more time?
Any questions you may have had about these terms have been answered by your
Yes, they have.
counsel? And are you under the influence of any medication or drugs or alcohol that would affect your ability to understand and agree to these terms?
No, I am not.
Do you believe that they're in the best interest of your grandchildren?
Yes, I do.
All right, Mr. Page, same thing. Do you understand all of these terms today?
Yes, yes, I do.
And your attorneys have answered any questions you may have?
Yes, I do.
And are you under the influence of any alcohol, drugs, or medications that would affect your ability to understand or agree to these terms?
No,
And do you believe they're in the best interest of your grandchildren?
yes,
All right, and you guys all understand that you're waiving your right to appeal any of these issues?
And
you're
each
gonna-
party to bear their own fees and costs?
Yes, each party will bear their own fees and costs. We hadn't talked about that, but that was assumed, right?
yes.
yes.
Okay, all right. Then I want to tell you all, thank you very much for being willing to talk with me and come to a reasonable resolution. I think that is in the best interest of the children and get you guys out of court and your children out of worrying about any court issues. Your children are very young and they have a lot of people who love them and they need everybody to be able to work together, and I'm hoping that you guys can continue on the path you're on and work forward to do what's best for them. They are just little kids and they need everybody's love, and I appreciate all of you working together to get this done. Any questions, anything else I didn't answer, or any concerns? All right, and you can each take your binders with you, but I appreciate you guys, and thank you, and have a happy new year.
You as well, Your Honor.
Thank
And
you.
Ms. Whitten, you're preparing, yeah, we already said that, you're preparing, okay, I want to make sure I covered it.
Just take